Of the law.
So we don't have any problem with you on that. Yeah. You know, you are here to challenge whether the bill, so far as you are concerned, you know, went through the proper processes. And your trump card is Article 108 and then Section 100 of Act 92. We are here. That is the main, you know, a course of action. That's why you are before us. But in the interim, you want us to injunct, you know, an arm of government, and that's where we have a little bit of a problem away.
We want you to address us on that specific question. In what, you see, you make the point that there's been a violation of the Constitution. That's your submission. Are you presenting that whenever there's a violation of the Constitution, the jurisdiction of the Supreme Court is so invoked that the Supreme Court cannot exercise its discretion to restrain itself to see whether that violation will continue or it will not continue? Don't forget that there has not been a determination of whether there's been a violation or not. That's your position.
Yes.
Or you think you've addressed us enough?
Milady, I think I've done my bit, but I still get the point you're making. And the point, maybe I'll add to it to see if I meet your expectations. The point is that the Constitution gave birth to Parliament. It gives it powers. It says do A, B, C, D. Don't do E, F, G. And then they overstep their bound to do what the Constitution says don't do. Now we are saying that if what they have been asked by the Constitution and the constitutional supremacy that don't do, if they do, the impugned act, if the bill becomes law, assuming all things being equal, it is signed, it becomes law, the damage or the harm, the indignity that the Constitution will suffer, the indignity that the plaintiff and citizens of Ghana will suffer, can never be compensated.
This is on the irreparable damage.
Irreparable damage.
In adjudicating on the plaintiff's application, the first issue, with all respect, is whether or not.
And so we're heading straight into the courts. Yes, I did say we'd be heading to the UK. That will be later, but we're heading into the courts now, and it has to do with the bill on proper human values. We call it the anti-gay bill. It's a mouthful. I've never got my head around that. But before we get into that conversation, under the distinguished patronage of her ladyship Justice Gertrude Tokonu, Chief Justice of the Republic of Ghana, the UPSA Law School proudly presents the 2024 Lifetime Achievement in Law Award and Honorific Lecture. Now, guess what? The event presents a rare but high-level opportunity to recognize and acknowledge the outstanding and exemplary contributions of notable Ghanaian personalities in the areas of the rule of law, governance, and the legal academy. This year's Lifetime Achievement in Law Award will be conferred on Nana Dr. SKB Asante, Paramount Chief of Asante Asokore and former Director, United Nations Center on Transnational Corporations and Chairman of the Committee of Experts which drafted the 1992 Constitution of Ghana at an august ceremony befitting the aura of the occasion. Now, the event comes off on Thursday, the 25th of July, 2024 at 5 p.m. at the Kofi Ohene Kunedu Auditorium at the UPSA. You can visit the social media platforms of the UPSA Law School or call 0245 347 946 for more information. Well, joining me in the studio on what has been happening in court and everything in between, I have my partner. We do a lot of things together, crazy things together. Richard Kwedunyako is head of our legal desk. Richard, Good to have you on the show.
Good to be here too.
My fellow Blackie. Anyway, so walk us through what exactly the two cases you've been following in Parliament, what the developments are, and then I'll bring in lawyer Amanda Clinton.
All right. So two cases came up yesterday. So but they centered primarily on essentially the same thing. So the first one was Amanda Odoi. She's a researcher at the University of Cape Coast. So he wanted an application for injunction to be granted by the Supreme Court for Parliament to desist from sending the bill that has already been passed in Parliament to the presidency. The second was Richard Delasky, a journalist and lawyer, and essentially also the same thing, praying to the Supreme Court to grant the same wishes. Their beef is that if the bill...
Has that been consolidated though?
No, so it wasn't consolidated. In fact, it came up and the Supreme Court said, well, they are not going to consolidate it. So they are going to give separate rulings to the two because there were some reliefs in Richard Sky's case that were not in Amanda Odoi's case. And so that is why they are not going to consolidate that particular matter. So as soon as the case was called, lawyer for Amanda Odoi said that he has an injunction to move. And so that was an application to stay the hands of Parliament from transmitting the bill to the presidency. And so they laid several grounds. But chief among them was Article 108, the fact that if a bill is being sponsored in Parliament, it should necessarily come from the executive, the president, because it has some financial implications. But on this particular one, the contention has been the private members bill that, brought to life this particular bill. And so according to the Attorney General, who also was tied in as the defendant in this particular case, Parliament had no business at all to have even given or entertained that particular bill in Parliament. So it became a banter between the Attorney General and then the lawyer for the Speaker of Parliament and for the by extension Parliament, also indicating that, well, why don't they wait for the business of Parliament to be completed? So when a bill is laid in Parliament, it goes through the various stages and all of that.
Exactly.
So it ends at the presidency. So why are they seeking to curtail the business of Parliament? And so that is the question that the Supreme Court on the 17th of July will be ruling on.
And some have raised the question about whether the court system or the judiciary, aka the Supreme Court, is not usurping the work of Parliament and all of that. What have been the reactions on that?
So interestingly, while that was happening, I guess that Parliament was also monitoring what was transpiring in court. And so the Speaker indicated that, well, any attempt to usurp the powers of Parliament will be fiercely resisted. But, we are all waiting for the 17th of July when the Supreme Court, whether the Supreme Court will be able to injunct Parliament that has not completed its business. So it's just like a chicken and egg situation. But the Attorney General is indicating that once the bill is transmitted to the President, Parliament has no option to come back and reconsider the bill. They have barely no option at all to come back and say that we are correcting any deficits or any breaches that may have occasion along the stream of things. And so that has been the position. In fact, when you said that some of the justices of the Supreme Court wanted clarity on the matter, whether when the bill is transmitted to the presidency, it cannot come back to Parliament for Parliament to rework on it. In fact, the default position that we know is that once Parliament is done with its business, you remember that in Mensma versus Attorney General, when there are acts that have been done by Parliament and they are deemed unconstitutional, you send it to the apex court, invoke the original jurisdiction of the court to interpret it, and then will strike down such provisions that are deemed as unconstitutional. But in this case, it's different because the argument from the Speaker of Parliament's lawyer is that the process of Parliament hasn't ended. It should end when the bill is finally transmitted.
Some have even said that some of these suits that were put forward were premature.
Exactly. Right. So it's just like the motion has not ended, but you are arresting it midstream. And so the argument has been, why don't you allow it to ripen into law, and then someone
take it from there.
under Article 2.1 can go to the court and say that, well, there are breaches of the Constitution, and the Supreme Court will rise into action and then deal with it.
That's my brainy colleague who we fool with the law here, Richard Kwadwo. He's head of our legal desk. Final point?
So my final point is that, recently there were some recommendations. 5 names came up from the Chief Justice. In fact,
including the judge sitting on
the
act of forcing case.
Justice Ifya Sewa Saribotri. In fact, the Chief Justice indicated that, well, because of the pile of cases that they have, and that is why they need more Supreme Court judges to be appointed to that place. I mean, essentially reaffirming the recommendation. But you know that once the recommendation came up, Professor Kweku Asare has written a beautiful piece about it, even indicating that the Chief Justice, by that action, is instigating favoritism in the judiciary, because why don't you appoint a lot of them, but you have
singled out
five of them, and then you want them to be nominated to the Supreme Court. The other one is that he feels that
we have to wrap, Kwadwo.
Exactly, he feels that it is a stated misbehavior that comes under Article 146, that the Chief Justice could even be confronted with that position, just like the removal of Justice of the Superior Court.
Right. Richard Kwadwo, thank you so much for giving us the scoop, the background to that story. But let me bring in now Amanda Clinton. She's a lawyer. Amanda, good morning. It's been forever. You've not looked for me in a while.
Good morning. Thanks for having me on the show.
It's good to have you join the conversation. And now let's look at this case that is before the Supreme Court now. Of course, Amanda Odoi and Richard.
Dr. Odoi.
Yes, Odoi, yes. I knew you would start doing that. And Richard Sky on this matter. What do you make of it, especially for those who have said that this is premature? Richard Sky heading to the court, that Parliament should have gone through its processes, the President should have assented to it, and then the justification would have arisen to fine-tune whatever problems there are with the law. Now it is in court. The Apex Court will rule on it on the 17th day of this month. Your take, your positioning on that matter?
Although it is a little premature, I can see why it's being done, because this is a test case. This is a test case because of the types of human rights being discussed, and it gives the Supreme Court an opportunity to speak to the Constitution and say whether there have been certain violations, or weigh that against family values, as well as weigh that against this, Article 108 provision. So they're taking the opportunity basically for the Supreme Court to define, what is a violation of certain human rights, like, freedom of speech, freedom to assembly, privacy of home, freedom of thought, association, information, etc. What I don't agree with is...
do you believe, do you side with those who say it was premature? Because there are clear processes. Once Parliament does its work, it's communicated to the executive. He can either sign, append his signature, give assent to it, or not, and state reasons. In this case, we have neither. And some have looked at that as a sort of lacuna. Yeah. Do you agree with those who say that this suit was premature?
Yes, the injunction part in particular is premature because Parliament has not completed its job. And it's also premature on a practical basis, because I think there was a witchcraft bill that didn't go through on the same grounds. For instance, there was no submission of an impact analysis on public funds. And so when it got to the president's desk, he could just say that he wasn't going to sign it because I think it was a private member's bill and there was no submission of an impact analysis. And so even if the injunction does not hold, the president can still decline to sign based on Article 108 because an impact assessment has not been attached, and based on the fact that, public considerations or public interest-wise, I think, for instance, World Bank will hold back $3.8 billion in the next 5 years if this bill goes through, as well as the other funds in the consolidation thing. So on a practical level, the Supreme Court doesn't have to say that the injunction must stand because the president can decline because there's no impact assessment. The Supreme Court rather can focus on the other case, which looks more deeply into the constitutionality, or looks more deeply into the provisions that have been cited, such as, discrimination, privacy of home, whether a person's gender, they have freedom in that regard.
Are you referencing Amanda's bid?
No, I think it's the other gentleman's bid.
Richard Sky.
His bid, yes, Richard Baya's bid stands on like 5-6 provisions, which each basically it's an open door for the Supreme Court to say, well, even though this is gay rights, which is not legal in Ghana, it's still a violation of fundamental human rights. So that's why it's been prematurely introduced. But whether the Supreme Court will take the opportunity to say that they're going to have an injunction, I don't think they will. They might take the opportunity to rather say, to rather define what are human rights and whether gay human rights have been violated. Because again, the president can say he's not going to sign it because there's not an impact analysis on public funds. And so it cures that. So it is a chicken and egg situation. But on a practical level, they should just allow the bill to pass to Parliament, I think. And then, the president cannot sign it based on this impact thing. And then, Parliament will have to tell us, because I'm not too aware if the bill can return. But I think it would be a bad precedent to stop a bill going to Parliament if the will of the people has been expressed at parliamentary level, basically.
What do you see emerging from all of this? What are your expectations ahead of the 17th day of this month? And do you think that the necessary processes, noting that the 8th Parliament is also drawing curtains on its activities, basically the political season is in full swing, do you foresee that we could see the end of this, whether an assent to the bill with amendments or otherwise, before Parliament draws to a close?
I definitely think we're going to see quite a few amendments because the bill itself, the substance of the bill is too much by anybody's standards.
What do you mean by too much?
Well, particularly the 5-year part where it says 5 years for willfully promoting or sponsoring or supporting LGBTQ actions. And, just from a legal perspective, what does one mean by promoting LGBTQ activities? Could you, in presenting your TV show talking about an underground LGBT activity, if this bill is passed, would you be considered as promoting it? Do you see what I mean? So the language of the bill, I think, is too strong. And the fact that the person promoting LGBT would also face more jail time than the person who's apparently doing the act that they don't like, which is sexual conduct at 3 years. I mean, it's draconian, without a doubt. I mean, this bill will certainly have to be revisited because it is draconian.
Let me make a quick point. If these changes are made, if that fine-tuning happens, would you then be in support of such a bill?
It's not my, it's not my place to say whether, because, my opinion, I think it's for Parliament to decide. But I do think that, we really have to look at this in the context of geopolitical world politics, how this could affect us, not only funding from World Bank and different places, but the sign it gives. And I think for the international community, where the international community are missing seeing the whole picture here in terms of African family values, is that within the African context, gay sexual acts it's sort of like, it's almost like within the African context, there's
Are you looking for the word taboo? Is that the word you're looking for, taboo?
It's not taboo, it's like, it's payments. Like abroad, it's about love. It's about two people loving each other. They should be free to be together, etc., etc. But within the minds of some of these politicians and some people in society, it's like you don't understand gayness in the African context in terms of, there is this huge connotation of, is there an exchange of money and is that why it's being done? Or maybe those taboos have to be overcome in order for us to start having the real conversation about equality of love, etc. I don't know.
Right.
The terrain is very different, and I think some of these subtle nuances have to be addressed, whilst looking at the bigger picture of geopolitical and the bigger picture of losing funding, etc. It's a lot more nuanced than is coming out. And a lot more work has to be done about the African perspective of why free love, might not be considered free love if it's for payment. It's considered, It's complicated, basically.
It is complicated, but I just had to make this point. I allowed you to go on. I would have interjected. The point has been made. Even at some point, I think there was a sneak release. It wasn't meant to come out. I don't know whether it was from the Bank of Ghana or something of the sort, that, if you go this way, funding and all of that. But there were a lot of ifs. But I can say this categorically. Countries like Uganda, among others, that have, and they have a pretty draconian law when it comes to gayness and everything in between. In fact, there's a chart. I just don't, because you mentioned it, I don't have all the details here now. But all of these countries in Africa that have gone that way, financially, there have been no such repercussions, not from the World Bank, not from the IMF, not from, bilateral partners and all of that. I just wanted to say that because oftentimes that is made mention of, but the reality on the ground is that these countries are not feeling any such pinch. I just felt it was my responsibility to bring that up. Before you go, and as I take your final words, in recent times, the justice sitting on the Atoforsen, Cassiel Atoforsen case, Justice Efiasewa Asaribotre, and 4 others have been put forward by the Chief Justice, which makes it pretty interesting. And some say the way she's going, it could be raising questions because usually you'd expect the president to do that and what the law dictates. What is your opinion on that? And then we can wrap this conversation.
Well, of course, it is for the president to decide, but maybe in the spirit of transparency, she does have a role in terms of the people she recommends to the president, etc. So maybe that's just being shown in a more transparent way, but the president is the person who ultimately decides. And, in choosing or in picking Supreme Court judges, it is also on the strength of the judgments that these judges have come up with and how deep their arguments are, etc. So it's not simply political or just political. You do have to have quite a bit of gravitas in terms of your ability to come up with judgments and to be a thinker, basically. So I think she's just being transparent, but ultimately the decision will be with the president.
Amanda Clinton, thank you so much for joining us this morning, and wish you the very best of the day. Amanda Clinton is a lawyer, and she was sharing her thoughts on those pertinent legal matters we have been discussing. But up next, after 6 weeks of intense campaigning, millions of voters across the UK go to the polls today in an election which has been projected to end the 14-year reign of the incumbent Conservative government. It is the first time since 2019 that the British people are voting in a general election, despite having been led by 3 different prime ministers over the same period. Now, the outcome of this election is crucial for the British people, but what does it mean for the migrant community, including Ghanaians living in the UK? We have some Ghanaians joining us from the UK this morning, and we're also going to be interacting with journalist Manuel Kranting, who has been following these elections keenly from London. All right, so we'll take a little breather. We'll be right back for that conversation.